Hello everyone, I am Dr. Nagraj Kharade, Assistant Professor, Sri Omkarnath Malpani Law College, Sangamner. Today we are going to learn about an important topic in property law, that is the drafting of gift deed. In this session, I will explain what a gift deed is, its legal provisions and the actual drafting of the deed. So let us see what the gift deed is. A gift deed is a legal document through which the owner of a property voluntarily transfers his ownership to another person without taking any money in return. It is governed by Section 122 of the Transfer of Property Act, which clearly defines what a gift is and how it must be executed. For a valid gift, it must be accepted by the donee during the lifetime of the donor. If the donee does not accept it, the gift has no legal effect. Finally, a gift deed must be registered with the sub-registrar's office and properly stamped as required by law. Without registration, the transfer of property through gift is not legally complete. Now that we have understood the basic concept, let us move towards its structure. A well-drafted gift deed generally follows a systematic format. Let us look at the main parts one by one. First, the title. As we are drafting gift deed, the title will be gift deed. Second, the date and place of execution. This records when and where the document is made. Third, the details of the parties. Here we describe the donor and donee with their names, addresses and other identifying details. Fourth, recitals. This section gives background and circumstances leading to the gift. Fifth, operative clause. This is the heart of the deed, where the donor states that the property is being gifted and donee accepts it. Next, the consideration clause. Although in a gift there is no monetary consideration, this clause confirms that the transfer is made voluntarily and without any payment. Seventh, the description of property. This part provides full details of the property being gifted, such as its boundaries, measurements and survey number. Eighth, the signatures of parties and witnesses. The donor, the donee and at least two witnesses must sign the document. And finally, acknowledgement and registration. The deed must be registered with the sub-registrar and duly stamped to make it legally valid. So this is the standard structure of a gift deed, and each of these components play an important role in ensuring the document is legally sound. Now that we have understood the structure of a gift deed, let us move to the next step. Before we start drafting, we need to decide the basic details. First, the title could simply be gift deed. Second, decide the date and place of execution. You may choose today's date and any place. Third, we must fix the details of the parties. Imagine the donor and the donee. Decide their names, age, occupation and address. For instance, the donor could be a father gifting property to his daughter or son. Fourth, we need to frame the recitals. This means writing why the gift is being made. It is out of love and affection or to settle family arrangements. Next comes the operative clause, where we will clearly state that the donor is transferring his property and the donee is accepting it. For the consideration clause, we will simply mention that the transfer is made voluntarily and without any consideration. We need to decide description of the property, such as a house, a flat or a piece of land. Think of the survey number, boundaries or other details that identify the property. So let us now decide these details step by step. Once we have them ready, we will draft our sample gift deed together. Alright, let's get started with the actual drafting of the gift deed. The very first part is the title. Here we write it on the top of the page in capital letters, gift deed, GIFT. Next, we move on to the date and place of execution. It usually begins with a formal line. For example, we can write this deed of gift made at Sangamner this 29th day of July 2025. This opening sentence tells us what kind of deed it is, where it is made and on which date. Now, after the title and date, the next part of the gift deed is details of the parties. In our example, let us assume the donor is a father and the donee is his son. This part is usually written in a formal way, beginning with the word between. So, our draft will look like this: between Mr. Govind Patil, aged 65 years, occupation agriculture, residing at Patilmala, Sangamner, Taluka, Sangamner, district, Ahilyanagar, hereinafter referred to as the donor of the one part, and Mr. Mahesh Ramesh Patil, aged about 38 years, occupation service, residing at Sangamner, Taluka, Sangamner, district, Ahilyanagar, hereinafter referred to as the donee of the other part. Notice how the donor and donee are introduced with their name, age, occupation and address, followed by a standard clause that covers their legal heirs and successors. This ensures clarity and completeness in the deed. After introducing the parties, the next important part of the gift deed is recitals. Recitals provide the background and explain the reason for making the gift. They set the stage for the operative part of the deed. Here is how we can draft it. Whereas the property bearing plot number 15 out of survey number 150 of the revenue village Sangamner, Taluka, Sangamner, district, Ahilyanagar, described in further detail in the schedule here under, is owned and possessed by the present donor. And whereas the donee is the son of the donor and the donor desires to gift the said property out of natural love and affection without any monetary consideration. These recitals clearly establish two things. First, the donor owns the property, and second, that he wishes to transfer it to his son out of love and affection. After the recitals, we now come to the most important part of the deed, the operative clause. This is where the actual transfer takes place and the rights of the donor and donee are clearly recorded. It usually begins with a formal phrase, "Now this deed witnesseth as follows." So, here is our draft: that the donor hereby voluntarily and out of natural love and affection towards his son, the donee, gifts, transfers and conveys unto the donee the immovable property more fully described in the schedule hereto, together with all the rights, title and interest therein, and delivers possession of the same to the donee. That the donee hereby accepts the gift and takes possession of the said property. That the gifted property is free from all encumbrances, liens, claims, mortgages, charges and litigation. That the donor has full right, title and authority to gift the said property. Let us now continue with the remaining clauses of the operative part. That the donee shall henceforth be the sole and absolute owner of the said property and shall enjoy the same peacefully without any let, hindrance or interruption from the donor or any person claiming under him. That this deed is made without any coercion or undue influence and of the donor's free will. That the necessary stamp duty on this gift has been borne by the donee. Together, these clauses make intention of the parties very clear. They show that the donee becomes the absolute owner, that the donor has acted voluntarily, and that the legal formalities such as stamp duty are duly complied with. After completing the operative clauses, the next part of the gift deed is the schedule of the property. This section gives an exact description of the property being transferred. so there is no confusion about its identity. Here is how we can draft it. The schedule of the property above referred to. All that piece and parcel of land situated within the registration division and district Ahilyanagar, subdivision and Taluka Sangamner within the local limits of the Ahilyanagar Municipal Corporation, Revenue Village, Khulewadi, bearing plot number 15 out of survey number 150 at measuring 2000 square feet and bounded as follows. On or towards the east, plot number 16, on or towards the south, plot number 18, on or towards the west, public road, on or towards the north, open space. So, this schedule makes boundaries and measurements of the property very clear, which is an essential requirement in every property related deed. Finally, every deed must end with the execution clause, where parties confirm the document by signing it. Here is the standard wording for it. In witness whereof the parties hereto have signed this deed at Pune on the day, month and year first above written. Below this, we place the signature of the parties. Donor, his name and signature. Donee, his name and signature. The last part of the gift deed is witness clause. Every gift deed must be signed in the presence of at least 2 witnesses who also record their names and addresses. Here is how it is written. For example, witnesses, name, for example, Rahul Kadam, his address and followed by signature. Then the second witness, name, for example, Meena Patil, address 120 Sainath Colony, Pune, and his or her signature. These witness signatures are important because they confirm that the donor and donee have executed the deed voluntarily in their presence. With this, our draft gift deed is complete. In this session, we learnt how to draft a gift deed step by step, from the title, details of parties and recitals to operative clauses, property schedule and signatures of parties and witnesses. This exercise showed us the correct structure and the importance of each part in making the deed legally valid. I hope you understood it. Thank you very much.